All right, I'll get started. And my introduction is the good news is that I have lots of experience doing what I'm going to talk about. The bad news is that means I'm senior counsel. So that's one of the good news and bad news. So this is a cartoon that my partner a long time ago and mentor would use almost before every presentation he did. So I had to haul it out for this since I have some good news and some bad news. Hopefully, even though we're going to be talking about product liability, sort of litigation themes, you'll see how they connect, and I will try to connect them to some of the things that were just discussed, especially as it relates to direct-to-consumer advertising, advertising in general, and regulation. What kind of regulation system, if it's going to change, what kind of regulation system we want. But we're going to go from the specific to the general, and if I don't make all the connections, ask me afterwards and we'll try to make them for you. So the agenda is this, not necessarily in that order. We're going to talk about how litigation's being brought and funded, how the focus has changed, and then some of the specific rules within how evidence is presented and or accepted or not accepted by courts to prove cases. All those things will hopefully never be part of your life, but could be because product liability litigation, whether it be about warnings or manufacturing defect, even though those are fairly rare, or design defect, always happen, and it seems like it's hard to be spared from that world. In any event, so by the way, I'm not focusing on healthcare and anti-kickback trends because my colleagues did a brilliant job in the first half hour, and I don't have enough time, so there's no reason for me to do that. So the first case I'm going to talk about in the first general category of cases is no injury consumer protection cases. So one of the things that I do in litigation is class action food cases where, and you've probably seen news about them, there's something in my food that I didn't like. You told me it wasn't there by saying it's natural or whatever else it is. And so the value of the food I purchased wasn't worth what I paid. It's that simple. I would have paid $1. Instead, I paid $1, instead it's worth 95 cents. Multiply that by however many consumers in a particular state, then you get damages that plaintiffs are worth chasing. In this particular case, it relates to antifungal medication, so it's a over-the-counter medication, and there's no allegation of injury. So it makes these unique. Since there's no allegation of injury, there's less proof burdens for the plaintiff, right? They don't need as many experts about how the device works. They don't need experts about what the physicians are thinking or what the standard of care is or any of that stuff. It's this medication had, and in this case, had benzene in it, and it was actually recalled in this case. So in some cases, there's a recall that triggers the litigation. In others, it's somebody finds out by looking at labels or testing. So there are testing labs that plaintiff's counsel uses with food, medical devices, or whatever it happens to be to find out what's in it. The larger context, I'm really backing up here a minute, is that things that are in our food and products are obviously being highlighted right now by this administration. So that's why this case kind of fits into one of the themes that our previous panel was talking about, because that's going to be a focus. You think, well, no, they're talking about the additives in Fruit Loops. No, I don't think so. They're talking about vaccines would be the next thing you think of. But I think that's going to be a focus for other products. Maybe not so much in implantable products or other products that you make, but it'll still be an important theme. So anyway, in this case, the claim is simply that, so this is part of the bad news. The claim is that there was benzene in the product, therefore I'm suing you and on behalf of every consumer, so you have a class action representative, on behalf of every consumer to get back what I should have gotten. So I paid $1. I think it's only worth 90 cents because it had benzene in it. And so we're going to sue that case out and mete out this money to all the consumers who fill out a card. You may have gotten them in the mail, right, for being part of class actions. Whether it's some 401k fund or whatever, you fill it in and send it in, you get some money back. So not normally the province of medicines and medical devices, but increasingly becoming part. And unfortunately, in this case, the court said, yep, there was an economic loss. The medicine did not have the same value as it would have without benzene. So there's a loss. And it doesn't matter if consumers don't have to prove that their particular tube or bottle or whatever of medication has benzene in it. So that's not a great result, right? Because the level of proof is small, right? Because we know you just have to convince and these rarely get tried, you just have to convince the finder of fact, the jury, that, and when you have an FDA recall, right, it's not going to be too hard to convince a jury that, well, it's like it's a 51% proof, right? It's a probability that that the product had benzene, so you win. So that is a trend that's continuing, and that is part of the bad news, unfortunately. So preemption, some good news. Preemption is a concept that comes from the Constitutional Supremacy Clause that said if the federal government makes laws that conflict with or are predominant in a field of law, then that law is the law of the land. It's called the Supremacy Clause. And generally, it needs to be expressed. So there's a statute that says this statute expressly preempts all state laws related. So any state laws that create different or more onerous regulations would be preempted by federal law. So you find it in the labeling laws of devices and food where there's express preemption, but not in every law is there a express preemption provision. So you have to rely on field preemption. Well, this case was a case of a chemotherapy drug, docetaxel, and it treats cancer, obviously. And there was a side effect of alopecia, and that wasn't in the warning. And this particular device was approved by the successor statute to what we used to call paper NDAs. And but the court said, you know, you didn't have enough evidence to show that warning would have even been accepted or needed to be considered under the regulations relating to changing your warnings, which is the change being affected regulations. So in that case, the court determined that the federal regulations preempted any state requirements that there would be. And usually the state requirements, I should back up, are consumer protection laws. They're not specific state requirements relating to labeling of drugs, right? Most states don't have. They have specific regulations specific to medicines or devices, but they do have consumer protection statutes that say that everything has to be truthful, it can't be fraudulent, et cetera, et cetera. So that's the importance of this case. And there aren't many cases that establish preemption for a kind of a new category of devices or medicines. And that's why this case is important. But it also raises another question. We were talking about deregulation before. So if deregulation occurs in the space of medical device and drugs, or food for that matter, what might fill it in the absence of express preemption might be disparate and maybe not, and maybe more onerous, or maybe not at all, state regulation. So also part of the calculus in deregulation at the federal level is what might the states do who are more concerned about protecting their citizens than the federal government. So do you end up then with a series of federal or state regulations that aren't consistent, maybe more difficult to comply with. So another thing to consider when making commentary about deregulation as invited by the White House, and that's how the preemption conversation hopefully relates back to general regulation of medical devices and drugs. All right. So the next one is the learned intermediary doctrine, and well, why do we care? Well, we care because science matters, and because science matters, we need people that know the science in order to defend or prosecute cases related to medical devices. And it also matters because of direct-to-consumer advertising, which we just talked about. So more and more plaintiffs might be empowered, and it's probably good generally. I mean, that's the whole idea of direct-to-consumer advertising. It's not just a profit-generating machine, it's also an information-imparting machine. So and we'll talk about this in a few minutes, but there's a First Amendment element to that conversation that'll have to be taken in consideration before we start banning advertising to consumers, as long as the advertising otherwise is truthful and not misleading. In any event, the learned intermediary doctrine is particularly important for medical devices and drugs because the doctor's the gatekeeper, right? The doctor decides what you get and why you get it and how it's supposed to be treated and how therapy is supposed to work. And the plaintiff can say yes or no, but the warnings go to the doctor. They don't go to the patient. Now they do in advertisements because we hear the end of every advertisement about warnings. In this case, it had to do with electrocompulsive therapy and the chance of brain damage or memory loss as a result of it. And one of the good parts of this case is the California court. You'll notice the California cases that are the cases that are problematic for the industry, California, good for the industry, Texas. But that's not hard to understand. But in this case, the Supreme Court said, yeah, the learned intermediary doctrine absolutely applies, and it's not a defense that the defendant has to prove. It just is. It's a concept. There's no issue about that. The bad part of the case is that they said that, so the plaintiff's argument was, well, if I think I would have said no, right, to the treatment, if I'd have known about the warning, that's all I need to show, right? I'm a reasonable person. If my doctor would have been told about that warning, and the doctor would have told me, and I would have had the choice to say no. Well, that's a great standard if you're buying cereal or something else. But for medical devices, the judge said, no. It can't be that easy, right? You have to be able to, the doctor is part of, if not the main part of deciding the safety of therapy, whether it be a device or a drug. But the court came up with a kind of a compromise concept that said the plaintiff only has to prove that the doctor would have communicated the warning had the doctor received it. So if the doctor got a change of label from the manufacturer and it said, yeah, you got this warning's being added to the label, in this case it'd be memory loss or brain damage, although might anticipate it if you're getting electroshock therapy, but and was probably discussed. Of course, that's the problem with these cases. They never tell you exactly what was discussed in the room. But in any event, the court said all the plaintiff has to show that the doctor would have communicated the stronger warning. Of course, that's kind of hard because you got to, the doctor is going to say, I don't know, right? Depends on the warning and the wording of the warning. Depends on the data. I mean, the doctors aren't completely ignoring what's going out in the field, right? You're not just handing them, take my word for it, give it to this guy, right? So that's a kind of a high standard, not as high as we think it should be. And the second part of the test, you have to show that a reasonable patient under these circumstances would have declined the treatment had they known the warning. So it's a little bit of a win and a little bit of a lose, but generally, for the court from which it came, it's pretty good news. And just so you understand why I picked this particular case and the consumer fraud cases, for lack of a better description, is the plaintiffs are trying to avoid what has gotten better for defense over the years, and that is the high levels of proof and the high levels of expertise they need to prosecute their cases. So by chiseling away at learned intermediary doctrine and other standards of proof, it becomes, for some reason there we go. So now even more obscure, Rule 702 of the Rules of Evidence. So this relates to experts, right? So in prosecuting, defending cases, you have to have experts usually, especially in this medical device and drug cases. So we find experts. Either they're people that we work with, physicians that have been advocates of our therapy, or they were researchers on the therapy, and those are the defense experts. And then the plaintiff finds experts, always harder, because they're not necessarily connected into the people that know as much as the manufacturers do. In any event, this case was a good case, and it related to a diabetes drug that caused, the allegation is that was causing heart failure. Excuse me. And in this case, an expert was proposed by the plaintiff, and the court, and that expert had not, it was one expert. And so what do you do to try to get rid of experts? You bring a motion to disqualify that expert. It's called a Daubert motion. If you get rid of the expert, you get rid of the case, generally. So that's why this is important. And the court said, well, that's great, plaintiffs, but your expert ignored contradictory studies. So actually, the court, those hearings are fascinating, they're interesting, and almost always the judges really care about hearing all the evidence. I've never been in a case where I've had a judge say, I don't care. The plaintiff's got an expert, happens though. Plaintiff has an expert, defense has an expert, jury will figure it out. It's all in. It's usually a pretty careful process. And in this case, the judge said, you didn't look at contrary studies, and the studies in which you did rely don't even relate to the injury. So the risks that you're bringing up in the case, they're risks maybe, but not the risks that are relevant here. So that's important. And then the rule was changed in 2023, the evidentiary rule, for the better, and that is it has to be a reliably applied methodology. You can have a person say, I've done tests and things and I've researched the data and find a bunch of evidence that may be contradictory and damaging to the manufacturer's defense, but it wasn't based on good science. And so that's why reliably applied was added to the rule, and why it's an important in this case, or an important case in this matter. All right. First Amendment to the rescue. So in California, there's Proposition 65, and you might or might not know about it. You have to give warnings of the inclusion in your product of compounds that could cause cancer or have reproductive health risks. And that's an industry in California for some lawyers. They just send out Proposition 65 letters about products, doesn't matter if it's food, devices, garbage cans, hose, whatever it is. They don't, right? Somehow you haven't put the very prescribed warning on the label that needs to be on there as set out in the statute. One of the problems with Proposition 65, it was written with the language that studies from a lot of different places, World Health Organization, other countries, can be considered in whether the particular compound in question should be on the label. So it's not just what happened in the United States. It's kind of wide open, and it's a shall language. If there's studies from the WHO that show that some compound causes cancer, you shall put it on the list, or at least put it in the system to be determined whether it should be on the Proposition 65 list. Well, anyway, in this case, Proposition 65 was going to require, well, I mean, the state of California was going to require that acrylamide be put, there'd be a warning. Acrylamide is most known as a byproduct of heating, so coffee. So every cup of coffee has acrylamide, mostly, if it comes from roasted beans and whatever. Toast, right? If you eat toast, right? A Pop-Tart or whatever. So it's sort of, the industry's going, whoa, wait a minute. I mean, what's the evidence that the amounts of acrylamide that are in these products, or any of the products that are requiring the warning, are going to cause any harm? Also, it's not in the product when they buy it, right? It's in the product when they make it, right? Or if they cook it, or whatever the case may be. So what are we doing? Plus, the studies aren't conclusive. They're not, it's not a settled science about acrylamide. It's prevalence, what's the dose, and what's the impact. So the government, in this case, a federal court in California, which is not always that friendly about these issues, said, no. You can't make people say things under the First Amendment if it's untrue or controversial, right? We can't be compelling speech that otherwise is not healthy or otherwise is not true, because the whole point of the First Amendment, this, don't laugh, is for truthful information to be given to people so they can decide things. Now, in the current climate, that may be failing a little bit, but in any event, that's what happened. So this is an important case for labeling, not just labeling of food or other products, but as there's more and more focus on what's in our products and more questions asked. We were talking about grass before. Just because it was on the list in 1958 doesn't mean it's free. I mean, that you can use it. They're going to be reviewing all those, not all of them maybe not caffeine, but reviewing a lot of those food additives, not food additives in the technical legal sense, but things we put in our food that maybe cause mental disorder in kids or whatever it is. So as that ratchets up, and the government believes there's questions about the safety of those products, there may be a higher demand for warnings. And then the question will be, is there enough science to make people warn about something that seemingly has been safe for 55 or 60 years? And that's why the First Amendment will be important in the product chemistry, for lack of a better description, going forward. And is one of the reasons I highlighted this case, is that trend in looking at what's in our environment and what we're ingesting and putting in us becomes highlighted. Finally, third-party funding. Sorry to end with bad news. But how did all this happen? How do the plaintiffs get the money to run all this up the flagpole, right? I mean, it's expensive to create class actions, and you're talking about cases that are difficult. The proof is difficult, and gathering up plaintiffs, class representatives is difficult. How does this get, how does an individual firm in some state fund it, right? It's not free. Well, people are willing to help them fund it. And so a trend that's been going, it's not particularly new, but continues to be part of the landscape, and that is third-party funding of litigation. And there's no law that's going to change that. It's a right to contract. People can take the financial risk they want to take. I suppose, I don't think there could be constitutional legislation to outlaw it. I don't know for sure, but it seems like that is unlikely. And so if you're wondering why we constantly have people after the industry, it's become easier to find the financing to do it than it used to be because the risk is spread out. It's not just on an individual or an individual law firm or even a group of law firms in that case, which leaves 2 minutes. If anybody has any questions. If not, we're caught up. No? All right.
Thanks, David. So we're going to take a 15-minute break. Please feel free to help yourself to refreshments. Restrooms are down this hall.